Good afternoon, everybody, and a pleasure and an honour and a privilege to be amongst you, and thank you to JPB for this great event. I've been given an opportunity to share a lot of information with you. We're here in the week that the United Nations will be deciding on a resolution to basically ethnically cleanse Judea and Samaria of the Jewish people, and to disallow, to make it illegal for the Jewish people, for Israelis, to be living in East Jerusalem, otherwise known as the Old City of Jerusalem, the heart of the beating heart of the Jewish people. We're at a moment in history, I believe, where the nations are making critical decisions, and they are using the language and the paradigm of international law to justify their positions. It actually has nothing to do with international law. It's much deeper than that, the positions that nations take, but they have to deal with this very complex and difficult thing known as international law. And I want to share with you today, we're going to do three things. We're going to look at how did we get here. 2024, we've heard yesterday and a little bit today about the Balfour Declaration, San Remo, the mandate for Palestine, which all promised the Jewish people a national homeland, the reconstitution of their national homeland in Palestine, living in safety and security. How do we get to the point where the highest court in the world, the International Court of Justice, 19th of July this year, says it is illegal for Israel to be present in the so-called occupied Palestinian territory, and settlers. The word settler means every Israeli who is living in those territories must be evacuated. We are talking about removal of the Jewish people from these territories. How did we get there? Secondly, I want to talk a little bit about the advisory opinion proceedings. We've been very involved in those. We've just come from a meeting with the Pacific Island countries. We are working with one of the nations there, Fiji, which put a very strong case in the international courts, and we're trying to build a coalition or help a coalition of nations to take an alternative approach to all of these issues. And thirdly, we'll talk about what can we do from here. So our organization, thinc, the Hague Initiative for International Cooperation, is a think tank based in The Hague in the Netherlands. The Hague is the international law capital of the world. It houses the two most important courts, the International Criminal Court, the International Court of Justice, based in the Peace Palace. And we're there at the heart of this proceedings in the International Court. Our work is research, it is education and advocacy. And when we started this work several years ago, we want to be a resource to the Christian world, to the Jewish world, to be a place of learning and study and education, not only about international law, but how law is misused and misapplied and misinterpreted to suit the ideological or religious purposes of groups of nations. So what is this concept of international law? So we are there to help you. If you ever need any advice, you want presentations or speakers, we would like to be there to serve you. We have a lot of resources. You'll find some of them at the table at the back as you go out. We've just released this report several weeks ago, fatally flawed, about the ICJ advisory opinion. We've done a report recently on the Iranian Revolutionary Guard Corps and why it should be placed on the EU terror list. We do a lot of work around the topic of Iran. We've done a research report on the two-state solution from a legal, political, and historical perspective, why the two-state solution is based on flawed premises. And we put the case for an alternative approach, which is not to deny the Palestinians autonomy or even a kind of self-determination, but they have to build it from the ground up. The international community cannot give them a state which is dysfunctional and which will be another failed Islamic state in the region. We have to put this case into the political domain. And then finally, our main book, Israel on Trial, that tells you the basic story about the legal foundations of the State of Israel and how international law has been used over the last 50 to 100 years to undermine the Jewish right to a national home. So, thank you. We're going to talk a little about history and international law, developments in the UN, the advisory opinion. If we next slide, please. So this is the lead counsel in the International Court of Justice putting the case for the state of Palestine recently. Last February, we were in the court for a week as the states presented their case. And the state of Palestine, as it calls itself on the international stage, even in the International Court of Justice, was represented by Philippe Sands. He's one of the most famous Jewish international lawyers on the world stage. And they put a very simple case. They say Palestinian right to self-determination is for all of Palestinian territory. They deny the legitimacy of the Balfour Declaration and the mandate for Palestine granting the Jewish people a right to reconstitute their national home. They say that is illegitimate. It contravenes our rights to self-determination. We were there, the Jews were not there, they came later. So that's their case. They say the settlements is basically an annexation enterprise. Israel, by placing its people in the territories, is effectively annexing territory. They say the occupation of this territory is illegal, and they even go on and talk a lot about discrimination and apartheid. I'll talk a little bit more about that. Yes, next slide. So I'm just going to do a very quick review, and please go quickly through these slides. I don't want to spend too much time. We've heard a lot about it. The Ottoman Empire, which collapsed in the First World War, included a territory that had become known as Palestine. That name was given by the Romans when they defeated Judea in the 1st century. Hadrian renamed it Palestine to refer to the Philistines and to destroy any Jewish connection with the area. And in the First World War, important decisions were made. Next. A decision was made to implement a mandate system. The mandate system was a very important instrument of international law to give the peoples of the Middle East and Africa and other parts of the world the right to self-determination. This included the people of Palestine. So the current state of Syria, the state of Iraq, and Lebanon, and even Jordan owe their boundaries and their existence to this mandate system. If we attack the mandate for Palestine as illegitimate, we have to attack also the mandates and the very existence of these other states. Yes, the mandate for Palestine was divided very quickly by Churchill into two parts. Next slide, please. Into Transjordan and into the area that was west of the Jordan River that was to remain for the Jewish homeland. And the mandate for Palestine, next slide please, was agreed at the Paris Peace Conference. It implemented the San Remo Resolution, which was a decision of the Supreme Allied Powers. They had that right, they had that entitlement as the victors in the First World War, and it was adopted as a mandate by the Council of the League of Nations. There was 51 internationally recognized states who agreed by treaty to give the Jews the right to reconstitute their land. That mandate still has legal effect because of Article 80 of the UN Charter. The rights given to the Jewish people under the mandate are still important today. That includes the right to immigrate, and it includes the right to settle the land, the right to close settlement of land. Next slide. We're going to go through these quickly if you wouldn't mind. As I say, it was divided by the British. 1/4 was left for the Jewish homeland, and 3/4 was given for the Palestinian Arab population. Jordan is an Arab Palestinian state. It is ruled by a Hashemite clan. The king is a Hashemite, but the majority of the people of Jordan are Palestinians. Why? Because that was created for them in 1921 to be their homeland. The Jews were not allowed to live in Transjordan. Next slide. The mandate was unique. As I say, it was legally binding. The beneficiaries were the Jewish people. The goal was to reconstitute their national home. And Great Britain had the responsibility as mandatory to ensure the Jews could live in the land, return from the diaspora after 2,000 years, and finally live in the land of their forefathers. And in Article 6, it gives them the right to enable, requires Great Britain to enable close settlement of the land. That includes Jerusalem and Judea and Samaria. And fourthly, it protected the civil and religious rights of all the inhabitants of Palestine. That's reflected in the Declaration of Independence of the State of Israel. And I believe it's one of the unique aspects of Israel. While being a Jewish state, it's always valued this important principle of ensuring that every citizen, every resident of Israel in principle has equal religious and civil rights. It is a democracy under the rule of law, unlike the states that are surrounding it. Next. In the subsequent 20 years or so, the Great Britain retreated from the mandate. They failed as a mandatory power to live up to their obligations. These are just four of the many different instruments that the British either implemented or proposed to create a two-state solution or a three-state solution or a one-state solution. They were always rejected by the Arabs. The Jews almost always accepted reluctantly these proposals because they knew they wanted a Jewish homeland. And the British tried to accommodate the Arabs for these years and failed until the mandate came to an end. Yes. 1948, the British had announced that they were going to depart Palestine. They gave up. They said, we're going to hand the matter over to the UN, which in the meantime had replaced the League of Nations. And on the 14th of May 1948, the British left and the State of Israel was created. Next slide. Israel is a state under international law. It is the only state that emerged out of the mandate for Palestine. Why is it a state? Because international law lays down criteria for statehood. It's a little bit oversimplified, but basically you need four things in order to be a state: a permanent population, defined territory, effective and independent government, and the capacity to enter into relations with other states. I think the unique thing about Israel, maybe amongst all nations in the world, is how for 2 or 3 or 4 decades the Jewish people built institutions of government. They did it deliberately, they did it effectively. So by the time the 14th of May came, the Jewish people were ready to have a state. And the state that was declared by David Ben-Gurion, next slide please, was in every respect a state that was sovereign under international law. Next slide please. In the meantime, the British, as I say, had announced their intention to leave, and the United Nations had proposed the partition plan. This was November 1947. You'll often hear it said that Israel owes its existence to the partition plan. That is false. That is not true. Neither the partition plan nor the United Nations in any respect has created the state of Israel. The Declaration of Independence mentions the mandate, the partition plan, but the creation of the state of Israel, like the creation of any state under international law, does not come through a UN resolution. The UN does not create states. It does not set the borders of states. It's very important to understand Israel's legitimacy, its existence, and its borders come not through the UN, but through general principles of international law. So the partition plan failed. It was rejected by the Arabs and was never implemented. This was the opportunity for the Palestinians to have their state. They could have had it. And everything that has happened ever since then has been an attempt to repeat this time and time again, because they keep rejecting the idea of a Jewish state. And I believe that is still the case today. The Palestine Liberation Organization, which is the entity that is driving all of this, even here in the UN. It's not the state of Palestine, which does not exist. It's the PLO. And the PLO National Charter still has in its provisions the liquidation, the elimination of the Jewish state of Israel. They want not a two-state solution, but a state from the river to the sea. We must understand this. They are not looking for a two-state solution. They are looking for a one-state solution. Next slide, please. So what were the borders of the state of Israel? Now, it's important to talk about this because it's very relevant to what is happening in the UN today. The Court of Justice, and therefore the UN General Assembly, is imposing the 1949 armistice lines as borders of the state of Israel. These were boundaries, armistice lines that were agreed to end the fighting in the War of Independence. They are not borders of the state of Israel. Neither Israel nor the Arab nations have accepted the 49 armistice lines as borders. And yet we have the highest court in the world telling the world that everything outside the Green Line belongs to the Palestinians. How do they get to that point? I'll look at in a moment, but basically because they ignore their history. They ignore everything that happened before 1967. And they say Israel occupied Palestinian territory. The fact of the matter is, when Israel was created on the 14th of May, 1948, it was created in Eretz Israel, in the Hebrew declaration. That means the land of Israel. And according to the principle of uti possidetis iuris, which determines the borders of states emerging from mandates or colonies or trusts, the boundaries of the mandate become the borders of the state that emerges. So in principle, Israel inherited the boundaries of the mandate for Palestine. That's everything up to the Jordan River, and arguably even right up to the borders of Jordan, or that have been given to Transjordan. But certainly the West Bank and Jerusalem belong within the borders of the state of Israel according to this principle. And there's no justification for applying this principle to every other state in the region and elsewhere, half of Africa, half of the Middle East, many other states in the world, the former Yugoslavia, when it was broken down into member states, their boundaries were determined by this principle. It creates stability in international relations. And what we have seen ever since then is the international community creating instability by dreaming up borders and boundaries for the state of Israel, which never existed. Next slide, please. This is the war that ensued the creation of the state of Israel. The West Bank, Judea and Samaria, Jerusalem, Gaza Strip were occupied by Egypt in the Gaza, by Jordan in the other territories, through an illegitimate act of aggression against the state of Israel. This is fundamental. If we're going to agree on the 49 armistice lines as borders of the state of Israel, we are agreeing to an act of aggression to create borders. This is creating chaos, this is creating uncertainty, and it's illegitimate. But that's basically what the court is doing. Next. So for 19 years, we had occupied territories. They were not called occupied territories. Nobody talked about the illegally occupied Jordanian territory. No, they called it the West Bank. Why? Because Jordan tried to annex it to the Hashemite kingdom of Jordan by calling it the West Bank of the Hashemite kingdom. But Jordan was occupying this territory. And so when we get to 1967, next slide, we come to Israel reconquering territory which had already belonged to it under the mandate for Palestine. In fact, it conquered more territory. It took the Sinai Peninsula. It took the Golan Heights. And we had a new phase of Israel's existence, and Israel entered into the idea that we will trade land for peace. Resolution 242 reflects this. After the Six-Day War, Israel will withdraw from territory, and in compensation, the Arabs will give peace. Now, we have seen, and Gaza shows us, October the 7th are the final proof that abandoning territory is never going to lead to peace. They gave the Sinai back to Egypt. They got a peace agreement with Egypt. They never gave back territory to Jordan, because Jordan never had a claim to this territory. Yet they have a peace agreement with Jordan. They have peace agreements with a number of the Arab world now, with the Abraham Accords. You do not need to trade land for peace. Unfortunately, in the period after 1967, Israel faced a difficult decision: what to do with the West Bank, what to do with Jerusalem. Israel decided to include Jerusalem within the sovereign territory of the State of Israel, to reunify the city, and later to declare it the undivided eternal capital of the State of Israel, which it was entitled to do under international law because Jerusalem belonged to the State of Israel. For the remainder of the territories of the so-called West Bank, Israel decided to treat it as occupied territory. For better or for worse, this is when the concept of occupation really kicked in. The legal advisor to the Ministry of Foreign Affairs, Theodor Meron, gave an advice to the government. He said, if you annex this territory, you're breaching international law because it's occupied. Unfortunately, I think the government accepted that advice and treated the territory as occupied. Israel has never accepted the Fourth Geneva Convention as applying to this territory. I don't go into the details of the law of occupation. It's complicated. There's an argument that you can have territories that are both occupied and disputed. Right? So Israel says we treat it as occupied, but it remains disputed. We have not given up sovereignty. We have never given up our claim to sovereignty over Judea and Samaria. But we treat it as occupied in order to look after the Palestinian population in the hope that we will have peace with the Palestinians. There was the Oslo Accords later in the 90s. And then the Gaza Strip also belonged to the territories that were treated as occupied. Now, this is where the idea came in that occupied territories mean that Israel has no sovereignty. This is not true. It was an idea that was developed by Europeans and unfortunately by leading lawyers in Israel itself, who argued, and I think the whole argument was, we need a two-state solution, therefore we will not claim sovereignty over these territories. But it's a non sequitur. It does not follow under international law that the fact that it is occupied means that Israel has no sovereignty. Israel remains the entity, the state that has the strongest claims to legal title over Judea and Samaria, stronger than the Palestinians, stronger than Jordan, stronger than any other entity. I think, unfortunately, Israel has not put that case extremely strongly. It's put a rather weak case, and that is that somehow sovereignty is in a vacuum, it's somewhere up in the air and it still needs to be decided. But under the principle that I just talked about, uti possidetis juris, Israel has strong legal claims to the territory. And we have now one judge of the court, Judge Julia Sebutindi from Uganda, who has put this case for the first time in history in the court, claiming and arguing the case for Israel's sovereignty over the territory. I think it's a miracle. We have a terrible advisory opinion, which is horrible. But we have Judge Sebutindi and a number of other judges who've given very important dissenting and separate opinions. And Sebutindi has put the case for Israel, and we need to build on it. I'll talk about that a little bit more in a moment. Next slides, please. We come to the United Nations. Okay, so Israel is treating these territories as occupied. It's negotiating with the Arabs for peace. How does it work in the United Nations? Well, the United Nations since 1945 has been a pro-Palestinian institution. through the adoption of General Assembly resolutions, committees have been established that are institutionalized within the UN to put the case for the Palestinian right to sovereignty over Palestine. And I'm not talking about a two-state solution. The Committee for the Inalienable Rights of the Palestinian People denies the fundamental legitimacy of the Jewish state of Israel. We need to be very clear about this. The United Nations, we as member states have allowed the United Nations to become a place which is denying history and rewriting the legal history of this territory. And we have done it through all these UN resolutions. How are these UN resolutions passed? Because the Arabs, the Islamic states, and the Arab Union always have a majority, either with the Soviets in the time of the Soviet Union or later with other states and groups of states. So they get these majorities passed time and time again. And the Western states have been too weak in our decision-making in the UN to stand up against this. Okay, a couple of slides more, please. I'm going to skip through from here. I'm going to talk, I have only a few minutes left, and I'm going to talk a little bit more about the advisory opinion proceedings. But let's be clear, the UN Charter is a wonderful document. Many Jewish jurists were involved in writing this document. The story of the contribution of the Jewish people to the UN is a wonderful story. And many believed that the UN would be the institution for creating peace and security on earth and protecting the rights of the Jewish people. It has become the opposite. It has become the opposite through this General Assembly one state, one vote system. And we have allowed that to happen. But if we go back to the very basic principles, they all actually protect the Jewish people. Equal rights and self-determination of peoples. There is no justification for treating Israel differently from other states. Why was Israel not allowed even to be a full member of the UN until very recently? Excluded from all the regional groups, excluded from committees. Because it was not treated as a sovereign, truly sovereign state. Every state is equal in the UN, and every state must refrain from the threat or use of force against the territorial integrity of states. In my view, the Court of Justice advisory opinion is breaching this value because it is justifying the Arab aggression against Israel over the last decades, including what is happening today. It's not only the Arab states in 48 or 67, it's also Iran, which is attacking Israel and enabling its proxies and allies in the region. Israel has a right to be free of threats and use of force. Okay, next. I'm going to draw to a conclusion. How did we get to this point? In the UN, in 2022, the General Assembly adopted a resolution that asked the Court of Justice for an advisory opinion on the legality of the ongoing illegal Israeli occupation. The court was asked to assume the occupation is illegal. It's a one-sided resolution, and we had one-sided proceedings. The court has come down with a one-sided advisory opinion. The resolution that is on the table tomorrow or the next day is based on a one-sided opinion. And I want to tell you today that we are advocating to states to vote against this resolution. We respect the court. It's a very important institution. But the court has failed in this case to live up to its task of reaching a judicial decision based on law and facts. It has gone along with the pro-Palestinian narrative. We are doing our best as thinc to make that possible. I want to thank you, and we must pray for the states as they enter into tomorrow and the day after the decisions that they have to make. They will make a decision wisely and push back against this revision of history and law. Thank you very much.